Good afternoon. My name is Ronaldo Hilton, the Chairperson Designee of the New York City Loft Board. Welcome to our March 6, 2019 public meeting. Section 282 of the New York State Multi-Dwelling Law establishes the New York City Loft Board. The board is charged with overseeing the conversion of interim multi-dwelling buildings from commercial and manufacturing spaces to safe, rent-regulated residences that comply with the minimum standards of safety and fire protection stated in Article 7B of the New York State Multiple Dwelling Law. To achieve this goal, the board adjudicates and mediates disputes between owners and tenants, tracks the progress of each building undergoing legalization, and prosecutes parties who violate the loft law and the loft board rules. Today, we want to welcome Deputy Assistant Chief of Fire Prevention, Chief Jordan, with us today, and he is the actual official designee to the Loft Board from the Fire Department, but he's here today to kind of observe things, so welcome, Chief. I don't know if he's open to say anything you want to say, if you want.
Well, thank you for welcoming me to the Loft Board. This is my first engagement directly with it. Rich Roach, who really represents the fire department and has for some time, certainly keeps me apprised of the actions of and the product of the Loft Board. So thanks for having me, and I hope to be a quick study and pick up and get value at some point.
Thank you, Chief. Appreciate it. The fire department, the role of the fire department is always welcome here. The opinions of and the board, so I appreciate it. And he's been doing a good job. Inspector Roche, Associates. Okay, we first turn our attention to the vote on the January 17, 2019 minutes. Are there any correction or comments on the minutes? Mr. Delaney?
Would I be correct that the two changes are that you took out the various little summaries of the summary calendar cases and inserted the conclusion as a summary for each master calendar case?
Yes.
My only other question is the prior draft had the 2018 Loft Board report PowerPoint slides attached to the minutes. Do you plan to attach those to these?
Yes.
Okay.
In the same page.
Yeah.
Any further comments on the minutes? Therefore, do we have a motion to accept the minutes? Mr. Cartwright, second. Mr. Barnes.
Mr. Howard?
Yes.
Mr. Bowers?
Yes.
Chief?
Yes.
Mr. Hernandez? Mr. Delaney?
Yes.
Ms. Roseman? Yes. Chairperson Hilton?
Yes.
6 in favor, 3 to absent.
Thank you, Mr. Rivera. We will now continue. We'll turn over to Ms. Wilson. We will now continue our discussion of those rules, rule changes, and Ms. Wilson will lead that discussion.
Mr. Chairman?
Yes.
Before we engage in the rules, can I just ask one question? I know that the architectural members of the board and some other practicing architects, I think, are around the time that they're submitting comments on these project guidelines. Do we have...
She was going to mention that.
Let the record show she's holding up an orange note. But I can't read. Do we have a plan to discuss that among ourselves at some point, or get a briefing, or...
So,
Just say what you're talking about.
yeah, so this is in terms of the project guidelines, so I did want to tell the board that Julie Torres Moskowitz and Ms. Ross worked very, very hard on comments which they did submit to the DOB team as well. Comments came in from the other architects who had been asked for comments. So all the comments are in, and when the document is finalized, yes, we will be having a briefing.
And will you distribute copies of the individual architects' comments to the board?
Do you want them?
Yes, I'd be interested.
Sure.
Do we have those?
Yes.
Isn't that a document for
GOP, is that public?
That's a good question. I don't know.
I don't know if we can do that, we'll check on it. All right, that's the internal document for the public buildings review.
Okay.
I'll see if it's considered public or not.
Sure.
I'm just saying.
Yeah,
I'm
yeah,
willing
yeah.
to do it, but I
Yeah.
just have to find out.
Yeah.
Just need to get
Copies of.
Sure, if it's the public, we'll.
Yeah, I'll send them to everybody. And then the other
I mean, the
thing.
project, I'm sorry, the final product is public, but the public copies,
And then the other thing was I wanted to introduce our auditor, Stan Pollock, who's sitting in the back, to everybody. So Stan is, among other things, does those really nice charts that you see that have all of the, where the buildings are in the process. So he's here for the first time at a board meeting because he doesn't usually work Thursdays. So I just wanted to introduce him. Okay, so in terms of the rulemaking, as I said in the email that I sent you, my intention is to...
No, I was just looking to see this, because all I get is a column.
So my intention was to go through and ask the board members the same questions that we had asked the attorneys and to get their opinions. Staff did have a discussion amongst ourselves and we have some thoughts, but we wanted to get more input before we did any kind of redrafting. And I would like to start with board members other than Mr. Carver and Mr. Delaney, since we sort of know where they stand, not that they shouldn't talk, but I think it would be good for the people, for the other board members to voice their opinions. So, the first question is, should someone claiming protected occupancy have to prove primary residence of the unit prior to the board granting an application seeking both coverage and PO status? And then what if the application just seeks PO status of an already covered unit? So, Mr. Barowitz, any comments on that question?
My feeling about that generally is yes. What I'm a little bit confused about is the criteria for primary residence.
So that's the next question, right? So we will get to that, and, okay. And so generally, yes, is your answer,
Yes.
Mrs. Roche?
I don't really have anything in particular as far as within what period of time. I'm more concerned about who.
Well, the question,
The chief has something that comes into his mind.
well, we're on question one, we're not on question two yet, right? So should somebody even have to prove that?
Oh, okay.
Okay,
My
so-
apologies. So I'm going to have to ask a bit of a question. There was, when the attorneys were here, if I tracked it right and we listened to them, it seemed like they were in harmony coming through history from day one of the Loft law until a certain point. And as I observed the four of them, it seemed like they were in harmony up until a certain point. And then something happened, and the attorneys for the tenants and the attorneys for the owners began to view things differently. So the reason I say I have to ask you a question to kind of state what's on my mind is because I need some historical background as to, did something occur, Mr. Delaney or Mr. Carver, that was beyond just political and just, obviously it's two separate interests. And is that what happened there? You had two separate interests that eventually just became more prevalent? Or was there some sort of underlying event that occurred that made that a difference of opinion?
I think the attorneys were talking about the change of form for the issue? Is that what happened?
Change of form
Housing court versus law board on the issue
of primary residence?
yeah, is that what Richard is getting at, I think?
No, I don't think so. I think, my recollection is that Mr. Brody said that the owners never really thought about it much in the beginning, and then at some point woke up.
Okay.
So
So that's kind of,
that's my recollection, that he said something along those lines, that
So
it
even
wasn't
though I
anything
sort of
that they were
stumbled
thinking
through
about.
it, the gist of it is that as time went on, it became more prevalent and more thought was put into it, and that was kind of what caused the parties to do it separately.
And I think the precipitating event that really forced the issue was the 2014 statute of limitations that was in the Loft law, where the board could no longer at that point accept coverage applications. So staff created a separate PO application and started looking at the rule more closely, but that really goes more toward the issue of prime lessees than it does toward primary residents. But anyway, I think that was a precipitating event.
I would agree in part with that, to the extent that, first of all, you're absolutely right from my vantage point. I thought,
You sort of saw the same.
well, Mr. Brody made the point that the tenant attorneys would have been equally happy to make, which was prior to a certain point in time, which seems to have been triggered by the 2010 law, that included a deadline on applications, but really came to fruition in 2014. All of a sudden, this question of, is the unit the primary residence of the person claiming coverage, the primary residence, which had never been an issue before.
Not coverage,
Pardon?
not coverage, protected occupancy.
Well, and
It says both are separate.
Well, and my point precisely is that when the board saw the deadline on applications coming, the board staff, without consulting the board members, created a new category of application called protected occupant. There was no discussion of that by the board. There were no public hearings. And it just came into existence. And in part, it was justified as a way to allow tenants in buildings that had already been covered or that already had applications pending to be able to avoid, to circumvent the deadline. But it had, from my vantage point, the unintended consequence of creating the current divergence of opinion. So, and part of my objection to this has always been that it was done, in this case, by the staff with no discussion, no notice, no seeking of approval from the board until all of a sudden, you know, I remember the first time a case on the PO docket came up, I said, like, what's this? And now there are two separate applications, so the application for coverage of the unit is separate from the application for protected occupancy. And from my vantage point, and if you read a whole lot of oath decisions, you'll see that for the most part, the oath judges have been in agreement that primary residence should not be part of the test for protected occupancy.
If I could just address Ms. Roslin, the question does say, right, should a person in protected occupancy, right, have to prove primary residence of the unit prior to the board granting an application seeking both coverage and protected occupancy. So it's well established that for coverage, you don't have to have primary residence. But because a lot of times we get both cases together, I thought it was important to understand that they're producing a lot of documentation just on the coverage aspect of the case anyway, albeit not necessarily enough to prove primary residence. So that's why the question is phrased that way. So, Mr. Roach?
No, I think that clears things up. I mean, I guess I would be inclined to say that for the sake of moving forward, if it used to work, and there really doesn't seem to be any reason that's being presented why it was changed, then why couldn't we roll it back to that pre-2014 thinking?
Well, I think the answer to that would be that the law has changed and the circumstances have changed. Things aren't the same as they were in '82. In '82, you had a whole bunch of people that were actually living there, and the law talks about a housing crisis. And I gave everybody Lower Manhattan Loft tenants, which is a Court of Appeals case. It's actually pre-1992 when the law was amended, but the Court of Appeals there, in discussing the eviction statute, the eviction rule, law court's eviction rule, talks about the purpose behind the law and whether or not there should be primary residence. And I mean, they are really coming out with, people are supposed to be living there. So I don't know why it wasn't an issue years ago. I think it should be an issue now. I don't know if Mr. Carver wants to address that.
Well, sure. So the question is, who do we want to be protected? And is it someone living elsewhere who's using this as a second home? I mean, wouldn't that really kind of make a mockery of the law? And the executive director gave a pretty lengthy presentation at one of our meetings that was held in the other building as to why she felt so strongly that primary residency should be a basis for that important status. And we had a case recently where someone was seeking a PO status who was not living there. I mean, is that who we really want to grant protection to?
But how frequently, Mr. Carver, I mean, again, you know, in the whole scope of how many hundred loft buildings we have and how many thousands potentially of loft tenants are in those buildings, how prevalent do you think that is? Because in the 5 years that I've kind of been doing this, I've met a lot of folks, and unless they're really doing a really good job of pulling the wool over people's eyes, they don't have a house out in the country that they're living full time and come in here once in a while. These folks are actually living here in these lofts. So I don't have a hard, fast opinion for which way this should go, but I think, you know, it is something that we have to make a determination on. But I'm also not sure how great of a problem.
Ms. Rosen.
We're talking about two different things at the same time. So the first is, so what you're speaking to is, should the person claiming protected occupancy be a primary resident, right? Which is to avoid those kind of things, especially with the rise of Airbnb and some other things that are happening in the current climate. And then also there was discussion about bringing it closer to or in line with residential rent stabilization rules. So there in a regular multiple dwelling, you need to be the primary resident to have the lease in the apartment, right? But the question is, do they have to prove it? Right? So we might all agree, there seems to be an agreement, generally speaking, as to whether the person seeking protected occupancy needs to be the primary resident. But then the question that where there's some where I see the divergence is whether or not they have to prove it. And that, some of the discussion with the lawyers had to do with tax return and mail delivery and how loft tenants often don't get residential, often have a post office box or some other way to get mail because they're either kind of trying to hide that they're there because it's an illegal occupation or occupancy, thank you. If some of the building is still commercial, maybe mail's like a 9 to 5 thing and they work and there's issues with getting important documents. So it was a little more complex when you came to proving the part.
So you don't necessarily have to get to the proving part. If the board decides that they don't have to prove it, then you don't have to get to how they prove it, right? So the first issue is, do we want to have a rule that's going to specify that they should be using the unit as their primary residence?
And to me, that's a yes or no answer.
Well, that's a simple answer. The point is that whatever criteria is listed here, the proof. For example, I don't own a car. My son owns a car, it's up in Maine, I have a driver's license in the state of Maine. But
Who has a driver's license in the state of Maine?
I don't own a car,
Where do you live?
but I live here.
It's
Now, I could,
against the law.
now I could, for example, say to you, well, actually, I have spent 184 days in the state of Maine, so I live in New York. There's no way, what I'm saying is that in any of these criteria, there's no way that it's absolutely proof. Mail, proof. I mean, I don't know how many hundreds of people that have bought apartments in the city of New York because of our dear old mayor that don't live here. Now, do they live here or they don't live here? And the way things are going the last number of years, you could certainly have a place in another country, spend more than 6 months here there, but then still retain a residence in a loft or another space in New York. See, that's what bothers me.
And
There's no way
be protected?
Mail doesn't prove it. If you don't pay your taxes, some people don't, you can't prove it. If you don't sign up to register to vote, you can't prove it. So I think that all of that thing is really kind of murky. And it really sort of bothers me because the world is beginning to change, as we know, and I'm not sure what kind of criteria we can actually begin to use.
Well, so that's a great point, is that so the idea is to legitimize someone's living situation or residency, right? So most people move, you move to a new city, you change your driver's license, you sign a lease, you set up a Con Ed account, you register to vote. Like, you want to show that you live here. Like, hey, this is where I live. This is, I don't want to get called for jury duty in California. No, I live here. I do my jury duty here.
I want to get called for jury duty, period.
Here, right, but it's the same thing. Like, I file my taxes here. I work in New York. Like, it takes a lot of work, actually, when you move to keep all your ducks in a row and let the government and your credit cards and like everybody know that this is now where I live, so you don't lose track of your life. But if you are someone who doesn't, kind of live in that same mainstream mentality, so it's I guess where I'm thinking about with this is it's almost like making a judgment call on someone's lifestyle choice. That's sort of where Elliot's going with this a little bit, right? So someone who's living in a loft may also not want to pay taxes or vote or do any of these things. They want to be totally off the radar screen.
The fact of the matter is that when the artist started to be formalized, living in lofts, there were a substantial number of artists that didn't want to even deal with it. They didn't want the city or the state to get in the way of whatever they were doing. And we still see that occasionally.
But I think for the most part, the people that are living in these spaces now really want to be there and want to be recognized, so,
Well-
again, we're talking about 2019. And there are differences between 2019 and 1982, and even between 2019 and 2010. So, we recognize one of the issues is that I think staff and the board recognizes that the quality of proof is not going to be the same. But the question still remains, should people at least have to say that they are living there and using that unit as their primary residence in order to be protected?
Can you just clarify for me, Helene?
Yeah.
When you say there are differences between 1982 and 2010 or 2019, it sounds like you're inferring that more people are gaming the system.
No, I think more people are, living in these spaces and want to be legitimate. I don't know how many people want to stay underground. I think the idea is to get out of the shadows and to be legalized. I mean, that's what we see from the buildings that we've covered so far, the 2010 buildings. I mean, there's lots of people living in these buildings. It's no longer 3 families. I mean, it's 85 families or 65 families. It's a lot of people.
So you say that, I guess the fear factor is not so
Right, yeah, I'm not sure that there's as much of a fear factor, but I reckon, I think that we, staff and the board, needs to recognize that it is an illegal occupancy and people aren't going to have the same kind of proof, but that still doesn't get us to the answer to the first question, because we never get there if we don't answer the first question yes.
Well, I would interpose a different question, which is primary residence, or is the existence of people who are not using a loft as a primary residence a bigger problem today than it was before? And the reason I agree with Mr. Roach is that the system is set up now based on the decision of the Lower Manhattan loft tenants case, where the loft tenants took a very extreme position in that case and said, no, you should be able to live in your loft even though it isn't your primary residence, all the way up until the building gets legalized and the owner joins rent stabilization. And only when the building becomes rent stabilized should somebody be subject to eviction for living, using a loft that's not their primary residence. And that position was soundly defeated, and the Court of Appeals ultimately said, yes, you have to use the loft as your primary residence to remain a protected occupant. So we have a system in place where the person who is a protected occupant, who's not using the unit as a primary residence, can be evicted. And consistent with the provisions of rent stabilization, as I think Bob Petrucci pointed out, in rent stabilization, the onus of raising the issue that it's not the tenant's primary residence resides with the owner to prove that the tenant's not using it that way, rather than the tenant having to try to prove that they are, where all these, well, but yes, your driver's license is from Maine, so all that stuff becomes something that the tenant then has to disprove. So there's a system in place to prevent that kind of abuse. And certainly also, unlike 1982, a lot of buildings have put in security cameras, both at the entrance and on different floors, which provide an owner with an opportunity to say, gee, I haven't seen Chuck in like 6 months, but there are all these people coming and going from his unit. So that actually the owner's ability, from my vantage point, to raise a primary residence question is that their technology is actually abetting that. I agree, technology also created Airbnb, which I lived through hell in my loft building for that, for a guy who started using it and was more than happy to see the owner evict him and put an end to that.
Okay, but Ezra wouldn't, so, do I have to, okay, so, I have to hold it down while I talk. If, after protected occupancy is established, then a tenant can be evicted for not using the space as their primary residence, then proving beforehand that it's their primary, I mean, I don't understand why. I get that there's sort of a principle here that we're discussing, but also, if on the day before you don't have to prove it, but on the day after you do have to prove it, what's the difference?
The difference is that on the day after you become a protected occupant, you're a protected occupant.
And so then you're protected. So you're saying like then the protections are in place and end of thought.
That's a good question.
I think that what you're getting at is that it doesn't give you any special protection being found by the loft board to be a protected occupant, because the very next day the owner can go into housing court and say, the loft board ruled that this person is a protected occupant, but this person's not using their unit as their primary residence, and I'm seeking the eviction.
And to what benefit would that be?
Exactly.
For the loft board to give you protection and then the landlord evict you the next day?
Right.
Right, on anybody's part, it also seems then like a little bit of wasted, like we're doing things twice, it's sort of a waste of resources.
And the burden of the courts.
Exactly.
So, in my opinion, I mean, that is just like a yes or no answer to, first of all, I mean, listen, we're not, this is not making any kind of burden necessarily on that doesn't already exist on tenants. This is a matter of saying, a matter of principle, a matter of law, should a person seeking protection under the loft law required to have the place that they're living at their primary residence? It's just a yes or no, and then we can get to the other stuff later as to how much of a burden we can, how much of a burden the loft board would put on those people to prove their primary residence. So this initial question is just a matter of law and of course principle.
I mean, the phrase primary residence is in our statute.
And was added to the statute.
I mean, and it's in the case law, so this is, I think the question is answered easily yes, and I even question why we're even asking the question in the first place, right?
Well, I think that the reason why we're asking the question is because the board, historically, what the panel talked about is how the board analyzed the question of protected occupancy historically. So prior to 2010, all you had to prove was occupancy. Then came 2010 and the cases after 2010 that talked about primary lessee, the application of 209, the application of 209B that talked about primary residence, and the question of primary residence in the statute. So the reason why we're talking about it, and I think why the board is discussing it, is because is the question whether does the board want to continue its policy or its decision making prior to 2010 that all you had to prove was occupancy, or are we now going to put into the rule as is stated in the statute that the person seeking protected occupancy status should also have to prove that that person that occupies their space as their primary residence.
Martha, you read the statute as saying that?
The statute says the words primary residence.
I agree that it contains the words primary residence, and they were inserted in 1992
Yes.
by the legislature, but I didn't bring a copy of the Loft law with me because I was carrying all this other stuff, but perhaps, I don't think it's as clear as Mr. Carver would view it to be.
Right, and that...
So I was going to ask Elaine if she would read the relevant page.
Prior to compliance with safety and fire protection standards of Article 7B of this chapter, residential occupants qualified for protection pursuant to this article shall be entitled to continued occupancy, comma, provided that the unit is their primary residence, comma, and shall pay the same rent, blah, 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 and that's what I'm going with. So, as I had said in my previous presentation, to me, the word continued, it's not to me, the dictionary definition of continued is something happened before, and it is continuing on after whatever the other event is. So they're entitled to continued occupancy provided that the unit is their primary residence. So to me, since it's continuing, it should have already been their primary residence.
And I read it to mean that, and as the sentence starts out, prior to reaching code compliance. So the presumption is that it applies to, and the statute says, protected occupant. It doesn't say applicant. And your question, Heather, is a good one. The day before I get registered as the protected occupant versus the day after, what's the difference? The difference is the day before, if the owner hadn't registered the unit and me, I'm not obligated to pay rent. The owner doesn't have the legal ability to collect rent. The owner has no onus under the Loft law to bring the building up to code compliance. So there's an event that happens prior to having a chicken, you have an egg. One day, instead of an egg, you have a chicken. So in the same way, a bunch of both rights and responsibilities flow to, are accrue to both the owner and the tenant when the unit is registered and the protected occupant is designated.
But then we have the problem that on the very next day, if the resident is not if it's not the primary residence, they would still face the housing court action, correct?
Yes.
Yeah, so that's still the problem.
It's not a problem at all. And in fact, we had...
well, I'll tell you why it is, but go ahead.
You want to go first, or I'll go first? I don't care.
Go ahead.
We had a case described by the attorneys where there were 6 units in the building, and there appeared to be some kind of primary residence question in one unit. So the entire proceeding at oath gets protracted, and the legal bills escalate over that one instance, whereas the other 5, there's no particular issue. So from my vantage point, it's much more efficient to have the owner register the building and then move against the person about whom the owner has doubts in housing court. So it's then the legal cost, the time and expense only accrues to the one tenant rather than to the whole group of people seeking coverage because the case can't go forward. And in addition...
I'm sorry,
It can be
I
separated.
disagree with that. I mean, that's a question of how the attorneys are doing their billing, to be perfectly honest. I mean, if I were one of the 5 other people in that case, I would say, I'm not paying for this. So I don't, to me, that's just like a separate contractual issue that has absolutely nothing to do with this.
Well, I can tell you lots of buildings I've talked to don't see it that way and don't treat it that way. And in addition, unlike rent stabilization, where the owner has to wait until 120 days prior to the expiration of a lease to announce to the tenant that he's not going to renew the lease because he believes the tenant is not using the unit as a primary residency, the landlord in an IMD building can go straight to housing court where the onus is on the landlord to prove rather than the tenant to disprove the allegation and set to it right away.
I'm not sure if we're doing any justice to anyone, granting them protection and having them evicted the next day. I'm not sure this board is doing any justice to that. I think we just need to answer this first question.
Can I ask a point of clarification? So in that scenario, in the 6-family scenario, I understand so we've got the building, we've got the units, the protected occupants. Those don't necessarily have to go through all at the same time, or they do?
That's really up to oath as to whether or not they would want to split it off. We don't have control over that. In a certain sense, it would make sense to split it off. You know, I could see as a judge saying, well, okay, I'm going to decide this issue and we'll hold this other one off. But there's also sense to trying it all together because a lot of the proof is going to overlap.
Right, no,
So, you know, you could do it either way.
So the answer is no, they don't have to go together. Or the whole building doesn't have to.
Correct.
But they have always so far.
No, that's not true. I mean,
Parties can settle different claims, and we've seen that parties agree to registration and one issue is remains. So parties are doing that now. They're narrowing down issues with the oath. They're doing that already.
So we are going to legalize all 120 of these units except for this one.
One claim that they can argue against.
Well, then are there situations where four units out of 20 are registered or more, and then someone comes along later and they want to add a couple units to the building?
Yes.
So that happens. So it can be kind of, and that's how I'm seeing it, right? So sort of piecemeal in a building. You can have 100 units and there's 50 different applications going
Yes.
out at different times, yeah.
yes. And sometimes oath will combine them. You know, let me say, we could address that rule, we could address that issue in our rulemaking, because the way that it works at oath is if the agency that's doing the referral has specific rules, they have to follow the agency's rules. But if there is no rule, then the oath rules govern. So we could actually address that in our rules and force them to do one way or the other if we wanted to. Whether or not that would be advisable, I don't know. I have to think about it. I never really thought about it before now. But that is something that we could address, or I should say you could address.
And look, in terms of resources, you know, the parties are already in the room arguing the facts at oath. It would be done. It would have to be done again in the housing court if an owner then has to bring a second proceeding. So in terms of raising legal costs on tenants, that would force the tenant to deal with those same facts twice in multiple
I
forms.
was going to ask that same thing. Wouldn't this be more burdensome on tenants in terms of legal costs?
I don't believe so. I think, first off, in housing court, it's the owner who has to present the case, that it's not the tenant's primary residence. I see Ms. Cruz nodding in agreement. Here, you've got a situation where the tenant has to prove that it is their primary residence. Prior to their appearance here last month, one of the attorneys, Bob Petrucci, provided an argument along with supporting documentation that I circulated to some of the legislators up in Albany, and I also sent copies to Elaine and Ronaldo, and I don't believe that's ever been shared with the board members.
I don't know what you're referring to. Anything that Mr. Petrucci gave to me was in his materials that he supplied to the board members at the last meeting?
No, I'm referring to a letter that he sent that I forwarded along to you and Ronaldo.
I think that's in his materials.
I don't think it contains the
But
discovery demands.
Yes, it does.
I don't believe those were circulated to the board members.
Okay. I believe he gave them out to the board members. I don't know how to resolve that.
I would ask you to take a look, and if not, will you distribute?
Sure, but as I've said multiple times, they're not helpful at all. So they're redacted, they don't show any differences. They were supposed to be submitted for the purpose of what discovery demands used to look like and what they look like now. And they don't address that issue.
Mr. Chairman, if I'm understanding everything correctly, would it be a fair statement to make that the staff is in favor of the primary residency clause and that their basis is that it better marries up with the statute?
So, yeah, so,
That we believe
yeah,
that says.
that's correct. So staff is
I'm
board.
not trying to put them on, I'm not trying to.
No,
put them
no,
on
no,
the spot.
that's good.
Everybody knows how I value their, because they do it day in and day out. And so I'm just trying to bear in my mind in one, simple thing that they feel that better marry up with the statute.
Right, so staff as counsel to the board agrees that, that primary residence should be proven prior to the grant protection. So that's what the board members, that's what you have. And I think, again, it's reading the law, it's they're taking the law, which should be respected. And that's what it is. I think we need to, as board members, you have to either take it or not take it. And I think that's what I'm saying. The answer here to the question, or one of the answers is either yes or no.
Mr. Barrett, do we have to vote on this?
I would think so. The thing is, I am so conflicted by this.
But eventually,
I don't even know if I can begin to make a decision.
this is not.
No, on the other hand, I don't know why this has suddenly come up and become a major stalling block in our deliberations.
We're trying to get to a set of rules that you can vote on. That's all. I mean, we have to have a certain conviction, a certain set of principles that we necessarily agree on first, and then we can, at least majority, so we can move on.
So it almost seems to me like we're going to have to vote, because I think
That can straw vote.
I think we can say
It is a
this
straw
time,
vote.
next, we cannot reach a consensus that everyone is going to say yes or everyone's going to say no.
So if we can get to first the question number one, yes or no, then we can move on to the rest and then so they can have some guidelines in which to frame the rule. And that's where we are. I mean, we can't be stuck on number one.
Can I just say that I viewed this meeting as trying to get what the board position is so that we could draft something for you to vote on. So, in terms of taking a formal vote on something, I don't know that that would be appropriate, and I did promise Mr. Torres-Maslowitz that we wouldn't be doing that. So, well, it just seems to me that you should be voting on a rule. So the purpose of this meeting was to say, well, what should the rule look like? So to the extent that you want to say, yes, it should include some language that says it should be that to be protected, you should be using the unit as your primary residence, then we will draft that. But if the board's view is that it shouldn't, then we will draft that other thing for you to vote on. But in terms of taking a formal vote on it, I'd rather draft something first for you to take a formal vote on. So, if the general consensus here is yes, it should include that, then we'll draft it that way. If the consensus is no, it shouldn't, then we'll draft it the other way. Or perhaps just leave it like it is.
What would we leave it like this result?
Well, leaving it like it is tough because clearly there's a lot of people out there that are unhappy, and we hear it from both owners and tenants, which I always say means if nobody's happy, we're doing our jobs because we're supposed to be neutral. But I think that it would be better for everybody if the board had a clearer rule. And I think that the rule as it's drafted now, particularly the except as otherwise provided, which is how the rule starts, creates a lot of problems. So we should redraft something, and we should try and make it clearer.
So if
I just want to make something clear also. I'm not a lawyer, and one of the things I know about rulemaking is that the rules are supposed to clarify the law, right? It's supposed to clarify the law in terms of operation, how do we do this? So if we have a rule that's more complicated than the law itself, it just does no good. So we should.
Well, I just wanted to, again, just speak my thoughts out loud. So if we say, yes, we'd like to see what you draft in accordance with having to prove primary residence, nobody is losing here, at least today. There's going to be an opportunity to vote
Yes.
yes or no if
Yes.
you want to do that.
That's
The only thing I see is that to in any way answer some of the other questions, you almost have to have an answer to the first question.
You do have to have an answer to the
Yeah.
first question, which is why it is question number
I
one. If the answer to question number one is no, then we go straight
I
to question
personally see
four.
no problem in looking at a draft from our competent law board staff that would indicate that you should have to prove your primary residence. For the sake of moving forward, I don't see a problem with that, as long as the board still has an opportunity to vote and say, no, we don't want this. Again, I'm looking for a way to try to move forward so we can accomplish
Okay.
one thing.
all right. I mean, for the sake of moving forward, I would agree with that, honestly. But that's, I mean, here it is. I mean, we don't want to waste time either, right? So, so the reason why we should be answering yes or no should be based on your take of the evidence you have in front of you, the presentations, the law, and just your rationale, the whole thing. I mean, everything should be, you shouldn't just be saying, okay, let's, for the sake of going forward, say yes, and then let's go and try
Well,
something.
no, I understand that, Mr. Chairman, but the problem that defaults to is that in essence, even if it is just a straw poll, you're voting. And I don't think the vote even at this point with the faces that I see would really show, one way or the other.
Are we?
I don't know. I'm at a bit of a loss for what we should do right here in this situation.
I say, well, you have my comments. Okay.
Is this specifically, does this show up anywhere else? You said the law, so it's specifically on page 2 here of the handout. The section 2-09B1, is that?
Yeah, B1, except as otherwise provided, yeah, that's B1.
So it says occupant qualified for possession of residential unit and protection under Article 7C1, except as otherwise provided herein, the occupant qualified for protection under Article 7C is the residential occupant in possession of a residential unit covered as part of an IMD.
Right, that's how it currently reads.
And then all the colored comments on the other side are,
The other side is proposed changes that we had made last year. But, I think that those changes are not going to go through, and what we're trying to do here is to figure out what we should do, how we should redraft.
So, Elaine, how do we move forward from this? We need to take, I guess the question that you're asking is, do we need, Mr. Roche, is that do we need to take a vote to Mr. Barros? You're asking him whether or not we need to take a vote on question number 1.
I think a straw poll
A
is
straw poll.
fine.
Well, in some way to be able to move in some sort of a direction. Otherwise, I mean, correct me, I don't know what, I didn't see a problem with them drafting something, but I do see a problem with making somebody do something that potentially isn't going to go anywhere. So the only other way to try to see which direction we're leaning is to take a straw poll and have each person say yes or no, and see where we're at.
And your point is that it doesn't seem like we'll be able to move forward doing that.
Well, Mr. Chair, there are 3 people who are absent in this meeting. I would recommend that we wait off until the 21st. I have no idea what the other 3 people's positions are. So, maybe they will say.
Two.
Three. Mr. Shachter?
Oh, yes.
Mr. Hernandez?
Mr. Hernandez is allegedly coming. So, I mean, he said he would be here at 2. Obviously, he's not here yet, so. But
One last question then.
Yes.
What's my question? So how often, do we know, how often does it happen that tenants are evicted for non-primary residency?
we don't know. We don't know. I mean, we will have times where somebody's applied for coverage or protected occupancy, and we find out as a result that they've been evicted, so the application is withdrawn, but we don't know.
I think by having this rule, would reduce those instances, right, of eviction.
It might, it's a very good question, and I think that the answer to that is not many, but don't know for sure. But it's a very good question.
Well, the other thing,
It makes a lot of this discussion sort of move. I think.
Right, if the answer was 0, then really we'd be like, why are we having
Yeah,
that?
right. Make the whole discussion.
the other thing to bear in mind is that, in my experience, under the old law, I remember running into a guy who was a loft tenant, and he said, yeah, I have a little weekend house up in Pennsylvania, and I register my car there because it's cheaper for insurance, and I think that was the main thing. And I mean, this is going back to the 1980s, and I asked him, and I said, how much the time are you in your loft in New York City? He said, oh, 300, yeah, I'm only up maybe 10, 20 weekends a year. But when the landlord brought a case against him, alleging that it wasn't his primary residence, in housing court, as a covered occupant, the landlord was able to go to that driver's license and raise enough questions that ultimately he couldn't afford legal representation, and he settled and left.
Right, but you're not supposed to have a driver's license in a state where you don't reside. Like that's against the law.
Oh,
So
I
understand living in a commercial space. Also, so we're kind of like now we're getting back to this question of principle that right? I mean, so you're saying, well, it's okay that this person should not be penalized somehow for evading, their.
I don't think violating the multiple vehicle law should be.
Motor vehicle law.
I know it's a minor infraction. I agree.
See, just to put another one, you have no idea how vulnerable artists feel.
No, I do.
And, Doug and I went to 2 meetings about the rezoning of Soho. And the first meeting is that somebody got up to speak, and a lot of the people that began to harass all of the city people. First of all, there was no microphone, there was not enough chairs. The second meeting got a little better. And I went around and I said to maybe it was the chair of the planning board, I think 70 or 80, 75% of the people here live and work in Soho. And he didn't know that. And finally, somebody lived here 1 to 3 years, maybe a half a dozen landscapers. How many lived here 5 to 10, more landscapers? 10 to 15, 15 to 35 to 50. And it was probably 90% of people, and they still feel, although they're protected by law, they still feel vulnerable. And I'm trying to harken back to something that a prominent critic, Harold Rosenberg, said about the eliminating of artists from Main Street, which was the first place that they began to live. Plus, in New York City, is the artists feel alien in their own territory. So I think that somehow, we did not bring up the word artists, and I'm sorry that I keep on bringing this up, but I think that that's primary in our concern, is that we are able to give the tenants that are living in the law some long-term protection. And even when they have it, they're not even sure they have it.
So, Mr.
The
Brown.
phrase being the tenants that are living in the law protection.
Right, the tenants that are living in the law.
So am I hearing that you are supportive of saying yes to first question?
I mean, I said I have a provisional yes on it, but I'm conflicted.
That's kind of enough for us to take a straw. Let's do a straw vote and see where we stand on this, and then if it turns out we don't have the votes to move forward, we move on, right?
May I make one more argument of substance? So, Chuck, you had argued that housing court may be more of a salvation for tenants because the burden of proof is on the landlord there as opposed to the burden of proof being on the tenant here.
I think you meant salvation in terms of cost.
Well, I thought he was saying that it's helpful to the tenant on the merits to be in housing court. No? Okay.
That's how I heard it too.
Okay. But if that were the argument, the counter-argument is that during the course of a proceeding, burdens of proof shift so that even in housing court, ultimately, the tenant is going to have to meet the factors to prove primary residency. I just wanted to make that point.
Pardon? Did I get you right? Yeah. Did I understand? Was I the only one who got you right?
I believe housing court is the place that this should be dealt with. I believe that it's up to the owner to bring a case. I agree that ultimately, if the owner says, well, is this your driver's license? It's up to me to answer those questions. But I believe housing court, after you're a protected occupant, is the way to address this issue. And I'm not going to participate in any straw vote. I'm not going to vote yes or no. I think having straw votes, particularly on a day that's not a regularly scheduled meeting with 3 people absent. Elliot says he's conflicted. I have no idea, for example, where Daniel Schachter stands on this at all.
What do you need to know where he stands on? What matters is where you stand, how you feel about it. If you voice it, what does it matter that Mr. Schachter?
Maybe he could persuade me to feel differently.
I don't. But, are we going to do this or not? I mean, is it the chair's decision to have the straw vote?
Well, one more question then. So could we propose, a different way of looking at the question. So we're talking about both should there be proof and should the protected occupant applicant be providing that proof. And then that's a little bit where...
Who else would provide it?
Well, I don't know, that's what I'm asking. Like, is there another way to look at this that may be...
You told me
The
burden.
question is whether it should be part of the test, whether it should be part of what the tenant has to prove to be a protected occupant, whether he uses the space as his or her primary residence. That's the question. So, whereas before, in 1983, that wasn't a question. Is it a question, or should I say, yeah, 1983, yes. In 1983, that wasn't a question. Is there a question? Should it be a question today? should be part of the rule.
That goes back to the question of what's changed.
Mr.
The law.
Chairman,
The law. I mean, that's the answer.
not to muddy the waters, but Chuck said something and a light bulb sort of popped on. You know, we're trying to determine what is legal, what is right, what's fair. And I know that Julie can't be with us today because of work requirements. Is extremely passionate about every component of this. And I say this for my colleagues that have other jobs that they block out time to come to law meetings. I understand that we can only get this room on a Wednesday and on a Thursday, and I understand we're under the gun to push forward. Personally, if you could have it on Sunday, I'll be here on Sunday, but I understand that's not everybody's reality. So I would have to say that Chuck brings up a little bit of a point when you speak about fairness. Some of the folks that have agreed to come on the board were under the impression that our meetings were always on Thursday because historically, they are always on. So I would suggest that
they're not here because of some lack of notice or something.
Well, it's my understanding that Julie simply can't be here on the
Right.
Wednesday meeting.
But that's
so-
what she was told, yeah, she was.
Again, I'm just trying to point out that Chuck may have a valid point there. That we're trying to decide something today that in fairness that people like to do. They simply can't be here. They have a career that requires them to be somewhere else, and this is not a Thursday.
But the decision today is not binding. It's an effort to help the staff move to produce something that could generate further discussion. That's what we want to get out of today.
Well-
Not that, we are here and we're going to the vote. It's more giving the staff.
Maybe our savior just arrived.
Hit the ground running.
If that's what we go into vote on, for the staff to draft something, I would vote yes.
We've been talking about this
But
years.
But if we're voting just to number down on the one, I'd probably would say, because I'd say I can't make a decision.
Well, that's the point, Mr. Morris. This is what we want to do. We want to be able to have a way to move forward.
Right.
That's just a way to move forward. If, for folks to, and as Mr. Bobbick is just saying, this is not something new that's been discussed just now. This is something that's been on the table for over 2 years. So it's not like board members are not familiar with the question. Everyone will have their opinion on the matter, but if we can't be stuck with not moving forward, maybe we can't say it, but we just can't we can't just not move forward. We have to have something to move forward. So we're talking about the text law. Primary residence. And then the question number 1. So,
Let me just say again what I said earlier. Whatever burden of proof that we have got down there, none of those things are absolutely positive burdens of proof. Sorry to say. Not taxes.
Absolutely.
not climate
And
sciences,
you're 100% correct.
No, that's right.
You're 100% correct. But here's the thing, and let me just address, I may be wrong here, but maybe, I don't know if I'm going to get in trouble saying this, but when it comes to the presence or absence of board members, if we have a quorum, and if we have a quorum on even if we have a majority of the votes on an issue, we have a majority of the votes, regardless of whether or not the other members are here or not. So that result would happen anyway. I'm not trying to be insensitive, but I'm just saying. And if we do that, if we always say that, then we'll never move forward as a board because it's very, very, very infrequent that we do have everybody's opinion or everybody's say in everything that we do on the board. So I'll leave it back to Ms. Wilson so we can decide or throw it back out. Are we going to answer the question, have a straw vote on the question number 1?
Mr. Hernandez, do you have any thoughts on
Not even taking my sweater off, so I can get processing what the conversation was, so.
We're talking about question number 1. So should someone claiming protected occupancy have to prove primary residence of the unit prior to the board granting an application seeking both coverage and protected occupancy status? What if the application just seeks PO status of an already covered unit? So the issue is, do we want to include language about primary residence in a rule? So, there's differing views. We would be interested in your opinion. Should somebody who is applying to be a protected occupant under the law have to prove that they have been using the unit as a primary residence?
I would argue yes, but I guess, yeah, I'd be interested in hearing whatever you want to share for here, so unfortunately I just got here, but, yeah, and I want to hear what the Desert Board has to say as well,
So I would give Mr. Carver and Mr. Delaney a chance to just kind of present their position. Since those two represent the two major.
Am I the decision maker here, or?
No.
Oh, okay.
No, not at all. You are the decision maker. All of us are decision. You're not deciding for it. That's what
And the issue on the table is the staff drafting something. The issue is not that the board is adopting that standard.
should the staff?
You need to know how to draft.
Yeah, should.
Well, frankly, this is not so much my position as it is that of the staff. That the law requires it. The Court of Appeals case that we have in front of us would suggest that we need it. And as a practical matter, do we really want people for whom the Loft unit is a second home to have this exalted status of PO status? If not, then you have a situation where the day after this second home occupant is granted PO status, winds up in a housing court proceeding, being evicted for lack of primary residency there, which strikes me and the staff as a waste of resources to have to do the proceeding twice. But I think Elaine, at a meeting that we had several months ago in the other building, made a quite forceful case as to why, in the midst of a housing crisis, you would want to give this status to a primary resident and not someone for whom the unit is a second home.
I continue to adhere to the principle that primary residence should not be an issue until one has protected occupant status. I would also point out that it was an unusual circumstance for us to have a panel of experts come discuss an issue with us before making a decision. And I'm still interested in hearing the opinion of all the people who heard that presentation before participating in any kind of straw vote.
My argument, I think, just having read through some of this, earlier through it, is, I guess, the protected, someone claiming protected occupancy should have to be able to prove primary residence. That's just based on me reading through all this.
I think we can take a strong oath of the people that are here. And then we'll draft something, and if it turns out at the next meeting, I'm not sure, with the 2-week turnaround, it may be tough, but we'll do it. If it turns out at the next meeting that would have to be drafted, we'll redraft, but at least we'll have a starting point. Different from the other starting point, which really was not started.
So do I have to phrase the?
Well, I would just ask the question. ask the
Point of
question.
order, that one of us outside of the chair has to make that motion.
To do a straw poll? But it's not a vote.
Well, I think what's a vote, it gets recorded.
Yeah, okay, but we just, okay. Somebody,
We can just raise our hand. We don't have to.
Then just raise your hand, then.
It's still recorded.
Huh?
It's still recorded.
so in answer to question number one,
If we raise our hand, it's just a number that's recorded,
Yes.
not the names.
right, in answer to question number one, should someone claiming protected occupancy have to prove primary residence of the prior unit, of the unit prior to the board granting an application seeking both coverage and protected occupancy status? And I should a show of hands as to those who say yes. I did.
The fire department.
And the chief.
Chief.
Yes.
Oh, wait.
Do you
I was
want-
looking at your.
I think that we should just put the number there, since this is a straw vote, that not identify
Yeah, no names.
the members.
Yes.
Just for clarification.
It's on TV.
The fire department did not.
I know, but the number.
Fire department did not vote?
No, we
Yes.
did
Oh,
vote,
oh.
we only raised one hand.
Oh,
In
okay.
case, just to clarify,
Okay, I got
in
you.
case it comes down later in the minutes, the fire department.
Okay, fine. So we'll draft that way.
I would like the record to reflect that I am not participating, I'm not voting no. I object to the concept of straw polls, whether they're in private meetings where we're trying to determine how we might vote on a case in public or in any other circumstance.
Okay.
You want to vote? Vote. You don't want to vote? You don't want your name on it?
This is just to move forward. We just voted on moving forward, Mr. Delaney. Just moving and making decision to move forward so that the board can do its functions. That's all.
And Mr. Chair, if I can just qualify that we voted in an effort to move the discussion forward so we can get to the vote in support of the.
Gotcha. Thank you. Thank you, Chief.
So now we get to question two, having had a straw vote for yes to question one. So during what time period should the person have to prove that the unit was their primary residence? So we have some choices. Do they have to prove that it was their primary residence on the effective date of the law? And that would only apply to people that are applying for coverage and protected occupancy. Obviously, if somebody's applying for protected occupancy in an already covered unit, it could have come at a later date. Is it the date that they file their application? Is it the date when, if there's a hearing, the record closes? So does everybody understand the concept of the three different dates?
Can you go again? Effective
Sure.
date of the law.
The effective date of the law, as long as they're not somebody that's applying after the effective date of the law. As long as they're not somebody who's applying for a unit that's already covered. Okay, on the effective date of the law, on the date that they file their application, or if there's a hearing, on the date the record closes.
Elaine, what about the concept of window period? Is that an issue here? Or is that just for coverage?
Window period is only for coverage.
For coverage, okay.
Right. So,
One more time, please.
sure, that's fine. The effective date of the law, the date of they filed their application, or if there's a hearing on when the record closes.
Is it necessarily or might we require more than one?
We could require more than one. We would have to figure out what the circumstances are where we wouldn't. I mean,
I seem to recall in one of the drafts that all of those elements were part of your draft at some point, no?
yes, well, yes,
Okay.
yes.
Good. So that would be,
Yes, you could require all three.
and that is in fact your recommendation.
Well, actually, I moved moved off the effective date of the law because I realized that if somebody is applying for a unit that's already covered, then they would never be able to approve that. They would never be able to approve that because they
Sure.
clearly weren't there. So clearly that part had to be redrafted.
But of course, that's only in certain circumstances.
Yes.
If someone were in fact in occupancy on the effective of the law, would you still want that to be, would you still recommend that that be a factor, or
Yes, I would.
a condition, yeah?
Yeah.
When, generally speaking, not just for this, but when we talk about effective date of the law, we're referring to the latest iteration of the Loft law?
We're
We're
referring.
not referring to 1983, right?
We're referring to the date, the effective date of the section under which they are filing for. Usually it's a coverage and PO together. So we actually recently had a case where somebody, even though it was way after 1982, they actually filed under 281-1. And so that date would have been 1982 for them, but most of the applications that we have now are under 281-5, and that would be June 21st, 2010. And clearly, if the statute is amended, it would be whatever date the 281-6, the theoretical 281-6 is effective. So yes, that's the date. That's how we've always treated it, and it would be very difficult to treat it any other way.
All right, and I'm sure I'll learn more about this, but this part from day one seemed a little arbitrary to me, that your building counts or doesn't count, or you as a person count or don't count, as opposed to whenever these changes continue to happen.
What do you mean?
Am I missing something? So the effective date of the law, so somebody that came after, so that was 9 years ago.
Right.
So we can't, if that were codified, then no building or occupant can be considered if they can't prove that in 2010 the building was occupied?
Now, okay, so that's coverage, so let's just put that aside. So it's whether or not they could be protected. And if we required everybody who's filing for protective occupancy to prove that they were there on the effective date of the law, then somebody who came later and moved into a protected unit, and we recently had a case like this.
But a protected unit, but if the unit wasn't yet...
A covered unit,
I mean,
sorry.
Covered unit. But if the unit isn't yet covered,
Well, if the unit isn't yet covered, then you can't be protected unless you're in a covered unit. There's no question about that, right?
but those two things often...
Go together.
Usually they are tried together.
Okay.
But we need to be sensitive to the fact that we could have a situation where coverage has already been established and somebody is now applying for protected occupancy. So they came later for whatever reason, there was no buyout or whatever, and now they want to be protected, and we should have a rule that is flexible enough to allow for that, because we want that. Or at least I think the board does. I shouldn't say you. So our argument as to considering when the record closes is the way that the rules are structured now. The board is supposed to consider everything that is in the record. So if we use the application date as the effective date, that could be problematic if there is testimony or other documentation that comes out of the hearing that shows the person doesn't live there, which we have seen fairly recently on more than one case, but one egregious case where the guy had just moved out and later moved back in, but that's beside the point. So the argument as to why we should choose when the record closes, our argument, staff's argument, is that the rules regarding hearings require the board to consider all the evidence that comes in. So that's why we think it should be that date. That's what that's.
And Elaine,
Which date are you saying?
The date the record closes, the last date, because that's where we have all of the evidence, and that should be the last date. The problem with doing that, which the lawyers pointed out, is that it kind of creates a rolling discovery request, and it could be very burdensome to the tenants. So, and I'm definitely sensitive to that, and perhaps we could tailor, in terms of discovery, you know, what kinds of documents they would have to produce after their initial production of documents to kind of mitigate that issue. Because I think that is a real issue, and it can create some proof issues and be very burdensome. So, I don't know about very burdensome, but be burdensome. So, that's just another thing to throw out there for you to think about.
So I'm just to be clear, you're saying you want either all three now, or
Well, I think it should be, for somebody who's applying for coverage and PO, I think it should be all three. For somebody who came later, then it should be the last two. What do you mean if you're looking for?
So the date of the application,
You live there.
live there for my permanent residence, but as of the date that it closes.
Do you think it should only be one? Which one do you think it should be?
Date of the application.
Okay. So Martha's opinion is it should just be on the date of the application. So then.
That's
so
a
then-
problem. I think that's a
Yeah, so the only problem with that is that somebody who testifies that they no longer live there would then be covered and evicted, would then be protected and evicted. Right, that gets us back to,
or maybe not, if it's not, if they
So if they testify that they live there on the date of their application, but they moved out 3 months later?
and they continue their.
we've had it twice.
And they continue the application even after it moves out. Are you saying like you could have that?
Let me just say this, with regard to housing court, my understanding is that once an owner files, is a 2-year look-back period. So the non-primary activity must have happened within that 2-year period. There's a look-back period. So as of the date of the application, do I want to move forward or look back?
Okay.
I think the effective date of the law needs to be amended because the owner's obligations start running from that point. Why should the tenants not also?
Then what happens if the tenant comes in later?
That's okay.
Yeah,
So
That's
from the
okay.
inception, either the effective date of the law or
Get
the
there.
inception of the occupancy.
Yeah, exactly,
Something like
exactly,
that.
yeah. And of course, the statute was meant to protect those people.
Right.
Yeah.
You saying that should be the only one?
No, all 30.
Oh, okay.
Yeah.
But the statute also provides that the unit remains rent regulated and another person could qualify for protection unless there's a deregulating event. So, you know, and the onus is on the owner to prove a deregulating event, be a sale of improvements, a sale of rights, or an abandonment. So, you know, to say that it was only meant to protect those people, I think it was also meant to protect the people that come later absent of
Yeah,
deregulating event.
yeah, I'm not arguing that,
Yeah.
yeah.
Okay.
Do you have enough to move on? Is there anyone else?
Well, does anybody have any comments on when the record closes? I'd be interested in hearing what Ford has to say about that.
I find these concepts a little hard to understand without a scenario or two, because, again, going back to, Martha, I appreciate your points about housing court. As I understand it, in housing court, the look-back period is 2 years, but in fact, if the leaseholder in a rent-stabilized apartment a year before the last year of the prior lease, let me put numbers to this. My lease expires today, and 2 years ago, I got a 2-year renewal. But secretly, I've been not using the unit as my primary residence for the last year of the old lease, the 2017 to 16 to 17. And now it's 120 days before my current lease expires. I get a notice that the owner is going to bring a holdover proceeding. If I have moved back, even though I wasn't using the residence as my primary residence, I was subletting without the owner's consent for the last year of my old lease and the first year of my new lease, but then I came back and I've been using it as my primary residence for the past year. It's my understanding that housing court is going to find that it is my primary residence.
No, I don't think it's something, I don't have to go back, because it's been many years since I did this sort of thing. I would have to double check, but my understanding is it's not something you can cure. If you didn't use your if you didn't use your unit as your primary residence, and the owner found out and filed the case against you, you can't just move back in and say, I'm here now. So, but I'm not sure about that, but I understand it to be something that you can't cure.
I don't understand that. I mean, you can move out and pay the rent every month.
Right.
Go out 6 months, pay the rent every month.
But paying the rent doesn't mean, just because you pay your rent doesn't mean that you are using your space as your primary residence. And even if you pay your rent, you
But
can
then
be
you move back.
evicted.
But then you move back.
But this,
Okay.
right, but that's what I'm saying, is that I think in rent stabilization world, it's not something you can cure. If you have not used your unit as your primary residence, and the owner brings a case against you, you can't just say, he found out, so I am now going to come back because he found out and I am now here.
But in
Now
rent
I have to trust that-
stabilization, you're allowed to leave. So this is where I think it gets sticky. So you can, it's in one of these documents, right? Military service,
Right, those are
school.
exceptions,
But
right.
there are exceptions. But if we're still on like this side of and not this side, right? Then the potential for someone, like there's not the whole subletting agreements within leases that are protected the way there is in residential multiple dwelling. So if I have a residential lease, it says, the law protects me if I want to sublet my apartment
Yes.
to go to school for a year, to do
Right.
something, right?
Mhm.
And the idea is that I shouldn't have to give up my living space and a rent-stabilized living space at that in order to further my education or to serve my country or whatever,
Right.
right? But if you don't have that protection yet, then you can't do any of those things without risking your coverage. Is that kind of where you're going with it, Chuck? I mean,
I'm just trying to understand.
but that would be a scenario. So I live in a loft, right? So I'm living there for 10 years, and one of them is illness. And so I am diagnosed with cancer, and I go live with my sister for 6 months to get treatment in Boston. And then I come back. And then somehow that's found out, and that disqualifies me.
No, it doesn't. I think, I don't have to think in front of me, but it's right here. In any other circumstances. Did it say something like that?
Yeah, I believe that there are exceptions to.
So I don't know how the
access.
housing court could But if you move back, whether you're subletting it or leaving blank, how the housing court can sort of say you can be evicted. When the law says, among other things, including illness and being cemetery, temporary job, it says any other provable circumstance. Am I right?
Reasonable ground.
Let's say that there is that exception, right? So the Loft Board has held that if you go temporarily before employment purposes, doesn't mean that you are not protected up, right? And I believe that there's something like that in the Unstabilization Code or law with regard to that sort of issue. But it's a different situation in which you are not living in your space because you want to live someplace else for a time period, not because of military service, not because you're ill, not because you are going to school, not for any of those reasons, but you're just not there. My understanding is that that's not something you can cure. It's not something you can say, I want to come back now because the owner has discovered that I am not living there, so I'm going to come back.
It would be helpful to me if we could get confirmation of that.
Yes.
Because I'm not quite clear on that.
Okay, sure.
Yeah, I mean, I'm fine with getting confirmation on that, but how does that impact the question that we're asking here?
I'm trying to, as you heard multiple people, not multiple people, as you heard the two attorneys state on February 14th, to ask people to prove now, and it appears the presumption, the language under the concept that's being considered is, this has been my primary residence all throughout the period of June 21st, 1910 till today. And there wasn't any period that I went anywhere for any reason, whether that reason was something totally bona fide like medical treatment or just, you know what, I went and lived with my sister for a year and I rented that lease out for 5 times what I was paying for it, and it was just, I wanted to make that money and on off of the landlord's property. So I'm just trying to understand what.
Well, I mean, we already have some exceptions that the board has decided in terms of, well, maybe in coverage cases, but also, I think, in cases too, or just coverage? Both, right? Yeah. I mean, we've already talked about people being away and working, particularly people being away and working. Right. We have
programs.
Yeah, we had somebody in the Peace Corps. We had somebody who was teaching in Michigan. We had somebody who was a television correspondent in the Netherlands. I mean, so we've had people that have been away for employment, and the board has said no, they should be protected.
Yeah, so I mean, the phrase primary resident would carry with it all the exceptions. So if you wanted to go down the housing court definition, which I know you might not, it would carry with it the exceptions, or you could make your own definitions with exceptions. So merely having the phrase would not preclude all the various exceptions that we all think of as still enabling you to claim status as a primary resident. That's not what the rule seeks to do. The rule is not seeking in any way to undermine that concept at all. In fact, I think Elaine is trying to make it looser.
Yeah, I mean, I think it seems to me that people that are living illegal, the reason that I'm so against just wholesale adopting all of the housing court law is because there is a different standard, and people that are living under the radar, and they have been living under the radar, are not going to have the same kind of proof as somebody who is living in a regular rent stabilized apartment. And our law is looking backward in time, and they're supposed to already have been there, right? That's what the law is all about. It protects people that are already there. So the quality of proof that they're going to have isn't necessarily going to be the same. And there are people, somebody said it before, there are people who don't believe in paying taxes and whatever, but they are going to have to come in. If there's a challenge, they are going to have to come in and they're going to have to sit before an oath ALJ, and they're going to have to convince that oath ALJ that they were living there. And, you know, sometimes credible testimony is going to be enough. Usually there's credible testimony and some supporting documentation. Unfortunately, we have really great cases coming on the calendar next month, but we can't talk about it, this month actually, but we can't talk about it because it has all of the different permutations. So, you know, I don't want to make a value judgment about anybody's lifestyle, but I think that the board has to make decisions, and the quality of proof that can be offered by the tenants that are living in this housing is different from the quality of proof that can be offered by the tenants that are living in housing court, which is why I have said, yes, they should have to prove it, but what they have to bring in is going to be different. That's my position.
Elaine, I'm actually glad you brought that up, because it was interesting to watch our 4 speakers. None of them agreed with that position.
I know. I was surprised at that too.
They saw some real practical problems with having 2 different standards, and I've always argued that you legally can't change the standard, and and we both rely on a Court of Appeals case, Lower Manhattan Loft tenants,
Right.
For each of our propositions. And the very attorney for the tenants on that case, I believe was here. Wasn't Ms. Petrucci on that case or no?
No.
Oh, he wasn't, okay.
It was Jeffrey Lee,
All right.
Mr. Cohen's ex-wife.
Yeah, but there are real practical problems. Mr. Brody brought up the issue preclusion, claim preclusion issues that could occur in a later proceeding that I think would need to be addressed if you were to change the standard from the housing court. But let me ask you this. Given that none of our speakers agree with you, have you changed your mind?
Well, let me just say before maybe I can jump in. I can say that I have not changed my mind. That perhaps it should be slightly different, because the truth of it is that many of tenants don't have mailboxes, right, in our buildings. That the mail is sort of thrown in this box, sometimes collected in the lobby. So the circumstances between getting mail, that sort of thing, I think is an important distinction to note with regard to our buildings, so that it would prevent someone from getting mail.
Right, but the housing court standard is quite flexible, right? I mean,
Right, no, I understand that there are other things that
no one
they
has
look at,
controls.
right? They look at taxes, they look at
And
driver's license, insurance. you know,
that flexibility helps tenants too. It's not only her,
Right.
it's actually helping them. It enables them to draw from multiple sources for proof.
But I think it begs the question that there are differences. So I'm not sure that adopting the wholesale law as precedent should be what the board does.
And I would say if we did that, what we would wind up doing is distinguishing our cases from the housing court cases, right? So you would have a case where somebody, you know, there's a case about taxes, although it's been watered down a little bit, but, you know, so you have a case where somebody filed taxes somewhere else. And basically in housing court, and perhaps I'm wrong, but I think, you know, the rule was, well, if you swore on your taxes that you lived somewhere else, then you live somewhere else, and that's it, you're out if you're in a stabilized apartment. You know, we could have a lot of reasons why our people file taxes somewhere else, not the least of which is they just don't get any mail where they are, or whatever. So, you know, we would probably in that situation recommend to the board that, yeah, you know, you have this case, this housing court case, but here's why the board shouldn't follow that case. Here are the circumstances that make it different from what would happen in housing court.
All right. This just came to me. So what, rather than throw the baby out with the bathwater, what if you bring in the housing court standard with a qualifier?
Right.
That, you know, rather than try to reinvent 40 years worth of regulation and exceptions and case law, what if you adopted it with a qualifier, what those words would be, I don't know right now, that said, you know, where circumstances unique to a loft require modification. Again, I don't like that phrase,
Right.
but it's that concept. You know, the hearing officer would be empowered to make an adjustment and to actually be required to state what the adjustment was and why they made it. That way, you're not trying to start from scratch. You know, you've got a list of 4 or 5 factors, but what good is that? Because life has so many complications. You know, how are these factors that we're trying to think up in this room going to really play out in real life? So that's my suggestion, just off the top of my head.
My concern would be on how we figure out these exceptions. And so if we're opening up the door to providing folks with an opportunity of being able to explain their specific circumstances, we've invited more of what we generally engage in here, which is a lot of talk. We can't make a decision, and it's just, you know, keep scheduling meetings over and over. So, and my concern is that we're not putting definitive qualifiers around this, and that we're just going to make this an open. We're just creating a lot more opportunity for us to not make a decision quickly on these things. I think sometimes we owe it to people to provide exactly the type of examples as to where we can provide, you know, a ruling. And if housing folks already do that, maybe that's something that we can respect and continue to adhere to.
I mean, I think it could be instructive. I think it's something that we can perhaps look at. I don't know if we should, if the board should adopt it as but I think it could be something that could help us make a decision. If it, for circumstances which are similar, perhaps, it would make sense on the policy level to adopt it.
Although having a specific set of criteria could actually backfire, because then we're always reacting. If someone comes and they don't meet that criteria, and then there's a debate, and then we have to change the rule again. And then if it's too rigid, then we're just going to be reacting to everything that comes before us.
Right. I guess, but we have something clear here that outlines your exceptions. I mean, then there's some language that says of reasonable grounds. If we could provide a little bit more clarity to what reasonable grounds were, I guess with that qualifier, then maybe it would make it a lot easier for us to be able to consider these cases when they come before us. It's just, I think if we leave it open-ended, it's going to be pretty difficult for us to ever come to a consensus on what those scenarios are that we should be accepting.
Anybody else?
The only thing that I have to say about all of this is that the resident, with me in the long run, it's very difficult to live in New York City. The rents are sky high. People are moving out. It's good and it's bad. It's bad that people are moving out. It's good for these other cities. They're getting the former New York City residents in their towns. And I think, you know, that's my bottom line on all of this. So let's make this as reasonable as possible. That's all. I agree with Mr. Fernandez. Let's try to make it as reasonable as possible.
Anybody else? Okay, so we'll try and.
Everybody's gone.
Oh. Harvest them.
So what are you taking away from?
So I think we're going to try and draft something that incorporates perhaps as guidance the standards in the housing code. I think that would probably be a good way to phrase it, to use that as guidance. But obviously there would be exceptions, but, you know, if we want to, and then we can think about whether or not we want to put any specific exceptions.
So
But
you bring in the housing code standards and then let's.
For guidance.
For guidance, and then let's cherry pick from there, or whatever, debate, basically, you know, see if you want to add something, take something, stuff out. Is that what you're saying?
Well, yeah, I think the way that we would draft it is say that the law and cases that have construed the law, the housing court, would provide guidance to the Loft board, but not necessarily be binding on it, because we could have circumstances that are different. So I think that's kind of all of the track that I'm thinking about or on the back of my head. Okay. So do we want to, if we could put aside 3C as to what type of documents, because I'd like to get some guidance from the board on question 4, which is the roommate issue.
Before we move forward on that,
Sure.
just so I'm clear, with regard to, we kind of veered off into the quality of proof, but with regard to question 2, what is your takeaway?
I don't think we resolved that, actually.
We just kind of slid on.
Yeah, we slid on to 3. I apologize. I don't know.
Well, I think that what came out of that discussion is that the staff is going to prepare a little bit of some information about how it's done in rent stabilization. So the staff will prepare, if I'm correct, the idea is that there's no cure, and whether the board wants to follow that or not follow that, if that's accurate, and go from there. So if it's not curable, then we can pick one of these and say, you know, the way it's done there's a look back period, right? So let's say it's 2 years, and so 2 years from the date of application, if that's how they want to do it, that's how you want to do it. Or if you want to if you want to make something that's curable, that's completely different. If I'm correct, that's completely different from what the housing court does. So I think we should first answer what the housing court does, and we will provide that information for you the next time we do rules, and then we can answer that question.
Can you just clarify what you mean by curable?
So if I'm correct, what happens is that the owner, let's say, finds out that you are not using your apartment as your primary residence. Then when the lease is up and you're up for renewal, then the owner can say, I'm not offering you a renewal lease, and I now find out that you live in Oklahoma, and you have not been using your unit as your primary residence, so I'm going to terminate your occupancy, and I'm going to seek eviction proceedings. So you get, I believe it's called a notice of termination, and then if you don't leave within the time period by when they say, the owner can then bring summary proceeding against you. And then it's the owner's case, so if the civilian is correct, the owner's burden is approved, and it's not your primary residence. But the tenant can't say, if I'm correct, that I have moved back. That it's not something they can cure.
I would just ask that if you're able to get, the more information you can get, obviously, the better, because that would be very helpful. In particular, if there's any precedent or, clarity around, gee, I got the Golub notice and I moved back from Oklahoma, as opposed to, yeah, I was in Oklahoma for a year, in our case, 6 years ago, but I've been back since that time.
Right.
So curable, so does the taint of having,
It happened 6 years ago, affect you today.
or from 3 years ago to a year ago?
Okay.
To the extent we're going to propose some language, maybe we'll just leave blank there. Because we haven't decided anything, and so we can fill that in later. So roommates, which is question 4. Should only the prime lessee be protected? Does it matter if the lease is in place? If we decide to protect others regardless of the lease issue, who should be protected? So, staff talked about this a lot. The law department had weighed in a long time ago. And Mr. Carver has raised it on multiple occasions. If there is a lease in effect, there's a contractual obligation. We could be impairing that contract. We could run into a lot of legal hassles. So ultimately, where we came out in terms of the recommendation was that if there is a lease in effect on the date of the PO application, because again, we go to the date, right? When does the lease have to be in effect? So if there's a lease in effect on the date that the PO application is filed, we should cover the prime lessee to the exclusion of everyone else. And if there is no lease in effect on the date of the PO application, we can cover everybody, anyone that meets the primary residence, etc. And then we also sort of came out saying that a PO should be able to add a spouse as another PO at any time. Obviously, if they're both prime lessees and they're both applying for PO status, that's fine. Or if they're both on the PO application and only one of the spouses is the prime lessee, they should both be protected. So that's how we came out. So thoughts, comments?
And just one comment. So the succession rules still hold?
Yes.
Oh, okay.
Yeah.
That's not changing?
No.
Okay, good.
Do we have statistics on how many loft dwellers in the city of New York have leases versus don't have leases?
We don't have statistics, but anecdotally, most people have expired leases. I think it's very rare that we see leases that are actually in effect by the time the loft board is making a decision. A certain percentage will have leases that are in effect at the time that the applications are filed, but then they expire and are not renewed.
We consider those as legit leases? I mean, do we consider those, if it's an expired lease, do we consider it as do we consider the conditions of that lease as ongoing, or?
So the way that the rule is phrased now, the definition section has that the person is the prime lessee, whether or not a lease is in effect. So if you've ever had a lease, you continue to be the prime lessee.
So you're saying that you want the rule to give preference to lessees only if the lease has not expired by its terms?
Yeah.
Which is probably no.
No, that's not true. I mean, it will actually incentivize people to renew.
Well,
Right, it would incentivize an owner, because the owner doesn't want to have to deal with the roommates, and it would incentivize a prime lessee, because the prime lessee may not want to protect Aunt Fran. So.
yeah, but the law, the common law, is probably in the RPL is probably statutory by now. Says that a month-to-month tenancy persists after the expiration on the same terms of the lease. So that lease is still alive by law. It just doesn't, if the lessee remains in occupancy after the stated expiration of the lease, that lease is not gone. In fact, often those leases have a special provision that calls for rent being higher in that period as an incentive to get the person to renew or to move out. So I don't see this as a viable legal solution that you're proposing. I think the lease in effect, or rather, if there ever was a lease and the lessee is still in occupancy, then I think legally the lease is in effect.
The person becomes a leasee to the extent that it's for 30 days. So if you pay your rent, if my lease ends in April, right? I pay my rent through April, I don't leave, I pay my rent in May, I become the leasee for that month. I don't become a leasee indefinitely, I become a leasee for that month, for those 30 days that I have not paid rent for. So come June, an owner can say, I'm not taking your rent because I want you out. And if you're not out by the end of the month, the owner can bring a summary eviction.
But I think if I'm understanding correctly, you're saying if like nothing is done, like if June comes and the lease that is in existence expires, but neither party takes any action to do anything, that 3 years later, if the person is still living there, that lease is what is looked at by the courts.
Yeah,
So there's a little bit of difference.
Well, I think that, well, let's be clear. If you are in a covered unit, you are a statutory tenant, right? If you're the prime lessee and the owner has registered the unit, registered you as a protected occupant, you are entitled to remain due to the loft law. So absent the loft law, I live in a two-family house. I have a 2-year lease. And once my lease expires, I am not renewed. The tenant, I become a month-to-month tenant. And as long as I pay my rent, let's say if my rent is due in the beginning of the month, I will be entitled to remain until the end of the month.
I'm sorry,
Entitled to remain until the end of the month because I have now made a rental payment for 30 days.
You're entitled to remain until the marshal evicts you.
Yes, but I mean, of course, but that's if I stay, right? If I stay, if the owner says, I'm not accepting your rent in the following month because I want you to leave and I'm giving you 30 days to leave, then I live in a two-family house, I'm not subject to rent stabilization, any kind of rent control, any kind of rent regulation. I don't have a right to remain, but our tenants have a right to remain.
Right, so the right to remain extends at least until the landlord gives whatever written notice is required to terminate that tenancy, which is past the stated expiration date in the lease.
Yes.
Okay.
That's true.
So your proposed rule would not consider, this is so good. A little distracted by the samba. Makes you want to do an interpretive section 281. Yeah, so, I mean, at the very least, your definition of a lease in effect should extend until such date as the law provides that the lease is no longer in effect past its stated expiration date. You're too short. In other words, if the lessee remains in occupancy
Mhm.
past the stated expiration date, that lease still lives so long as the landlord does not, at the very least, send the notice to quit. So if you're going to go in this direction, I would ask that your definition of a lease in effect properly reflect the state of the law on this issue, whatever it may be. I'm just telling you off the top of my head what I think it is, but it could be different. And when I say the state of the law, I mean the fact that the lease survives on a month-to-month basis past the state expiration date, and that additional occupancy should count towards the definition of a lease in effect.
That's what we have now.
Yeah. What we have now is whether the lease is expired or not, you still consider it a permanency.
Well, this is a little less than that. It's if it's expired and the landlord has given a notice to quit, I mean, I guess I'm conceding that if the law says that's the end of the lease, then that would be a cutoff.
The landlord can't give a notice to quit. They're protected under the Loft law. How can the landlord give a notice to quit?
I thought they're not protected yet. Well,
So that's going to incentivize, no, because even if the case is pending, they can't be evicted while the case is pending. Can a tenant who filed an application for coverage, for protection, say coverage and protection, be evicted while the case is pending if the lease expires?
Well, they should raise their claim, and their defense, that the unit is subject to ground regulation and they're entitled under the law.
okay, so it's defense.
Right.
So then I think this new definition isn't going to legally work because of the fact that the lease legally survives if the lessee stays in occupancy past the stated expiration date. I don't see how this new structure cures the whole economic reliance issue that you're trying to overcome.
Yeah. But what he's talking about, let me see this sheet that you're referring to. Is it this one? For the question side?
I'm not looking at anything at the moment.
Oh, okay.
I'm just reacting to your statement that that your change is now that to grant a lessee preference over other occupants, the stated expiration date of the lease has not yet run. Is that what you're saying?
On the date of the application, yes, that's what we're saying.
And I'm okay. And what I've said is that's a problem because legally, technically, the lease still survives if the lessee is in occupancy, notwithstanding the stated expiration.
They just give them a terms, they may be paying the same amount of money, but I'm not sure.
No.
It's who's then the lessee.
Well, no, according to the rule, it's the person who's the lessee in the lease that is now expired.
Now,
Exactly.
right, but.
The terms of the lease
Change that.
survive.
Right, they're paying the same amount as long as the owner is.
It's not necessarily the same amount. The lease might specify some other amount in a holdover situation.
Or they would even say, I'm not.
In a non-IUD situation.
Yeah. Because these leases are not going to be residential leases either, right? These-
Right, the commercial
Yeah.
business, yeah.
And so they're actually likely to have a holdover rent. In fact, they're likely to be contemplating some sort
Right,
of
but
holdover.
if, let's say they have a holdover rent. I mean, so what? The rent is regulated by the Loft law now. So it
No.
doesn't matter?
Well, but the issue is, the issue is who are we protecting? So, and maybe that's the difference, right? So, it's so hard for me to wrap my I'm sorry. So if the lease has expired on the date that the person who was the prime lessee on that lease files their application, why should only that person be protected?
Because
I
they're
think
technically
Mr. Carver's
still the
argument
lease
is,
holder.
right, I think Mr. Carver's argument is because the lease survives and they're still the prime lessee.
And if they're still in occupancy, there's, I believe, and this is some research that would need to be
Yeah,
done.
we can do
I
that.
believe the lessee remains a lessee under the same terms as the lease provides, only it's on a month-to-month basis. So the lease still lives. So all the economic reliance arguments in favor of giving the preference to lessees still survive.
What happens if there's no lease, it's just a so-called, excuse the expression, a gentleman's agreement?
Well, I
Which I'm
think-
sure takes place. You you give me X number of dollars a month, you can stay a month. Or lease, just a agreement. Does that in fact have all these?
And I think under the proposal and under the current rule, everyone can qualify absent of prime lessee.
Right,
Okay.
Yeah,
right.
that's not changing.
It requires a lease, not this gentleman's agreement.
Right.
Oh, okay, a lease, there needs to be a piece of paper somewhere.
No. For people to be protected,
No, for
for the prime lessee to trump everyone else, is that right?
What if a second lessee would like to be, or a second person would like to be added to the lease and the landlord refuses?
If we follow Mr. Carter, what he just said, that person would not be protected. Because the lease,
Right, trumps, I get
right,
that.
the trump everyone else.
Then, but is there a provision to, if the prime lessee, all right, so hypothetically, this, we say yes to this, we agree that prime lessee is the original leaseholder, there's a second party that wants to be added but isn't added, and the prime lessee agrees, can there then be two protected occupants?
It's not the problem, I see that would have to agree with the owner, right?
Right, I mean, the owner can certainly register an additional protected occupant, but it's when the owner isn't consenting that the issue arises. And the board has already said, well, we definitely want to protect more people than just the prime lessee, and we were stuck with the who. And I think everybody was in agreement as to spouses, whether or not we were going to go beyond that.
Once the unit is covered and the occupant is protected, can then a second occupant come down? Can someone else? Can you later add protected occupants to units?
My understanding is that you have a right to add a spouse.
Well, in rent stabilization, you have a right. In rent stabilization, you have a right to add a spouse. You can ask the landlord, that I actually would have done. You can ask the landlord to add your spouse to the next renewal lease. The problem here is that we don't have renewal leases usually.
But is your question really that, can we have more, let me just propose you on, but can we have more than one person as the prime lessee?
Sure.
Right?
Yeah.
But they have to have been at the time the lease was signed, I guess.
Yes.
So you can have, other people can be on the lease, not just the one person.
No, that I get, right? If three people, business is the same way, like my business and we're in office space together, I get this half, you get that half. But yes, it's all at the landlord's discretion.
If you want to, because I
Well, or
guess-
even split a lease, so if some, and oftentimes that's not the case, usually they want to hold, oftentimes they want to hold one, they want to have one sort of point of contact, right? They don't want, you sign a lease with two parties, and one party leaves.
Right.
There's nothing really, I mean, so then the party that's still in place is responsible for taking over the entirety of the lease, right? But that just causes so many problems, because oftentimes when two parties enter into a lease, it's because they can only afford half the lease. So
So it'd be up to the landlord to decide.
I think that's an unusual situation in my experience. It's an unusual situation that landlords are amenable to multiple parties entering into a lease agreement.
Well, look, certainly a proposal is, from my perspective, preferable to the prior ones, even though I would not support the
Right.
change. But I think that the change does require a little more legal research. And then even once the legal research is done, the question then becomes, so what? In other words, would we care?
Right, well, yes. To the extent that I don't want to open this up to lawsuits, we pass a rule that could be struck down.
Of course, yes.
Having gone that route once at ECB, I don't know that I want to, which it wasn't struck down, but it was very nerve-wracking. I don't know that I would want to do that again.
Sure.
So, okay, we'll do more legal research on that issue and come back to the board. So we'll draft something, but nothing on this particular issue, I think, because I don't know that we can even phrase it. Okay?
That's question number 4, correct?
Yeah. Question number 5, I don't know that it's relevant to this discussion. We could actually go back to question number 3C and talk about the types of documents the board would be looking to see, or we could talk about limiting discovery, but I haven't really thought that through yet. But I do know that there have been multiple complaints about how burdensome discovery is. And if we are going to go with answering question 2 to the end, the day the record closes, we should fashion something, I think, that would limit discovery from the application date to the date the record closes. I just don't know what form it should take. If anybody has thoughts on that, I'd be more than happy to hear them.
I just want to point, Helena, on that issue, I certainly see the concern, but once a person applies, their incentive to kind of live underground kind of ceases, right? I mean, would they be more likely after the application date to have proofs? In other words, your whole concern was that they may lack proof because of the type of occupancy that's going on. But once an application is made public, would there no longer be a reason to have a lighter burden?
I think it's a different issue,
Okay.
right? So the first is that they may not have the same kind of documentation that somebody in housing court would have, and that's one issue. The other issue is the burden of continuous discovery
Sure.
during time the case is pending. So to the extent that we would want to address that burden, I think it's something that the board should at least consider.
I think so too, for sure. But once an application is made, the person with our rule would then be on notice of a requirement for proof. So,
Right, but
the tenant would not be blindsided anymore.
But that doesn't necessarily mean that they still wouldn't be overly burdened by discovery requests,
I agree.
right? Like,
I agree.
give me 5,000, give me 5,000 documents, right? to prove coverage and protected occupancy. And, you know, you're talking window period documents, and they have to come forward with those things. But then, in terms of protected occupancy, if we go the route of until the record closes, there's a continuing burden. So how many of those 5,000 do they need to produce until the record closes? Do they need to produce all 5,000 for every single month until the record closes? That to me seems like a lot.
I agree, Elaine.
There's
but-
got to be a middle ground.
Right, but certainly, I mean, starting at 5,000 is not necessarily,
I don't know, we've had,
Fair
well, okay.
1,000.
Yeah, 1,000 is certainly, I mean, having looked at these records, you know, you get these binders from Oath, these huge binders from Oath, page and page and page, and bank statements, and every page of the bank statement. Why do you need every page of the bank statement? Isn't the cover page good enough? Yeah. what were you gonna say?
Well, right now we have basically 3 or 4 or 5 criteria. In no way do I see that non-square legally that you live there. Why isn't that listed? You swear to an authority that I live there, I live this place. Why isn't that sufficient for my, it's not listed.
it's the conclusion.
Is that case, could that be case law then?
There are cases where we based off protected occupancy and coverage all the time.
Testimony.
Testimony.
Okay.
Credible testimony is as important as a document.
All right, well, I haven't seen it, but you have used that.
You've seen cases before you.
Yes, I know, I know.
And you'll see them again soon after, that there are, we base it on credible testimony.
Okay. But
Yeah,
if we
Michael
put that in, is one of the
mentioned brought that up
criteria,
before. Sometimes.
it's credible testimony?
Yeah.
I mean,
As this a factor?
yeah, yeah.
We can discuss listing it, but the whole point, you go into trial, if you're testifying on your own behalf,
Right.
that should be as important as.
Okay. See, I think that that's probably the best burden to prove, because if you lie, you're in serious problem.
Yeah, but you have another whole trial to determine if you're lying or not.
The perjury trial?
I'm sure there's many prosecutions of people who lied to the law. Yeah, it's nothing better than
In both parties.
Yeah, well, that's true.
Yeah.
Well, I said people, but you said things. Okay, well, I guess what I would say is, I would ask the board members to think about discovery. It has been raised over and over as overly burdensome. And to the extent that we can do something, I don't know what, if we're going to extend the period to prove primary residency to when the record closes, then I do think we should couple that with some sort of limitation on the continuing burden for discovery. So if the board members could think about what we would want to do, should we go that way, and we can work on crafting something. So.
So it should be, excuse me, I'm kind of congested. But are we saying that the board should sort of take a position or be in a attempt to make the burden, the whole thing with discovery less burdensome on tenants?
I think in certain situations, we might want to do that, and we should think about how we do that.
In that final period,
That's my proposal
Yes,
in that
yes,
final
yes, yes,
period.
yes.
Yeah.
Does anyone have any other comments on what we've spoken of so far? We're going to end here, but does anyone want to wrap it up with any further comments?
just want to wrap it up.
That's your comment? Okay, so this will conclude our March 6, 2019 Loft Board meeting. I want to thank everyone for their participation. Our next public meeting will be held on March 21st, 2019, at 2 p.m. right here at 22 Greece Street, Inspector Hall. Thank you. We are becoming very intimate with each other for the frequency of these meetings. Have a good day. Board members, please sign in and hand in